Hi, welcome to another edition of Education Matters. I'm Ray Pinney. I'll be your host. Today we'll be talking about a Supreme Court case, Mahmoud v. Taylor, about opt-outs. If you have any questions or comments, put them in the chat room, and we'll try to pass it on to our guest, David Rubin. Hi, David. How are you?
Ray, thanks for having me.
David, you're with the Busch Law Group. Just tell us a little bit about your experience. I know you've been practicing educational law for a while.
I have. I was admitted in 1977, which means I've been practicing law for, I guess, close to 50 years now. A while back, I joined Busch Law Group in Metuchen with a lot of old friends that I've known for many, many years. We've got about 20 lawyers in our firm at this point. We practice all over the state, represent about 100 school districts or so in one capacity or another, and this is how I spend my time these days.
So this case, I think, is pretty interesting. It breaks from previous rulings to a certain degree, but can you give us the facts on this case?
Sure. The case on Mahmoud versus Taylor was decided at the end of the Supreme Court's term last June, and it had to do with parents' ability to opt their children out of course material that they found to interfere with the religious upbringing of their children. The result really didn't come as a surprise to many of us who've been watching the trajectory of the court's rulings over the last 30 or 40 years. And I think it's important to understand what the case means and where we might be headed from here, to put the case into a bit of a context. When I started practicing back in the 70s, the First Amendment hasn't changed since it was ratified in 1791, but the interpretations of it have changed over the years. And when I started back in the 70s, we were applying a test to determine whether something was an establishment of religion. That's much different than the test that the current court is applying. Back then, we applied a test that some people call for short the Lemon test, which had nothing to do with lemons. It was based on a Supreme Court decision called Lemon versus Kurtzman back then. And that test, as it evolved over the years between the 70s and into the 80s, focused mainly on how certain practices were perceived by people in the community. So translating that to school districts, whether a particular practice or an event might have been perceived as endorsing religion, a particular religion or religion in general. If that was the case, most courts back then applying the so-called Lemon test would say that it was a violation of the Establishment Clause and school districts had to stay away from it. In the 80s, going into the 90s, as the courts began to move steadily to the right, the emerging majority on the court, it started out as a minority that's now become the majority, but there were justices on the court who were trying to push back against that test that focused on appearances and in favor of more of a test focusing on whether people were being coerced to participate in religious activities. The argument they made was that this perception test that the court had come up with in the 70s was completely made up by the court at the time. It had nothing to do with how folks back in the founding era in the 18th century would have understood the First Amendment when it was adopted. And if you go back then, in fairness to that point of view, if you go back then and look to see how the First Amendment might have been understood in the 18th century, religion was very much a part of public life back then. People could even be punished for not attending church under certain circumstances, although they had opt-outs back then as well. And we have a court that's been moving steadily in the direction of being more receptive of religion in public life. So beginning in the 80s and certainly into the 90s and into the 2000s, in a series of Supreme Court decisions, the court in one case after another expanded their receptiveness to religion and its role in public life, and particularly in school districts. They took the position that it's one thing to be neutral in terms of religion, it's another thing to be hostile to religion. And they took the position that applying this appearance test not only advanced neutrality, but it got to the point where people were being denied benefits solely because of their religious beliefs, and the current majority doesn't buy that.
So in this case is from Maryland. So what were the facts in this case?
Yeah, a bad set of facts for the school district. And when I say that, I have to go by the facts as the Supreme Court found them, which, as we all know who practice in this field know, may not be what actually happened in the case, but by the time the case gets litigated and findings are made in the lower courts, that's the record that the Supreme Court is stuck with. And if you look at the facts as they found them, we had a situation where a school board in Montgomery County, which is, I think, by all accounts, including theirs, is a left-leaning county politically. It felt that there should be more of introduction of LGBTQ-themed material into the curriculum at the elementary grade, so they required teachers to read from LGBTQ-themed storybooks throughout the school day as part of their language arts curriculum. It required those books to be on the shelves in the classroom for kids to look at when they wanted to. Some parents who had religious objections to that raised them. Initially, the school district accommodated those requests to opt out of those courses, of that material, until they changed their mind and decided that they didn't want to do it anymore. And why they changed their minds is a matter of some debate in the case, but at some point after having allowed it, They said, we're not going to allow this anymore. And then this turned into a federal court case that got into court, and where the court ultimately decided that those parents' rights to opt out of that material took precedence over any administrative burden the school district was trying to establish in the case.
So in that case, they said it was administrative burden to opt out, but they all had previously already
They had
done
previously done it. They allowed.
it. So that's what you mean by bad.
Well, they had started off by allowing it, and then they changed their minds. They allowed opt-outs for other courses. Here in New Jersey, for example, we have opt-outs that have existed for years for, everybody knows about the opt-out for certain portions of the health curriculum related to sex ed. Many people don't know that there's another opt-out if you don't want to be exposed to dissection in biology class. There's a statute that allows people to opt out of that as well. Generally speaking, though, folks don't get to opt out of the curriculum. We have certain state requirements that districts are required to teach. We have certain state assessments that kids are required to take. But for those two examples I mentioned here in New Jersey, at least, there's nothing in existing law that allows people to just generally opt out. Of course, if people have a right under the First Amendment free exercise clause to object to something because it infringes on their religious beliefs, the First Amendment being federal law takes precedence over our state law. So that's the question here, is whether there was a right to opt out.
And I'm not sure if we mentioned this, these are elementary school students.
Elementary school students, which played a big role in the court's decision here. They focused on the fact that these are young, impressionable kids. They indicated that perhaps the result might have been different if these kids had been older. And this is not the first time that the current majority in the court has drawn a distinction between young, impressionable elementary kids and older kids who may be able to make up their own minds about things. Some of our listeners may recall the case a while back, a couple of years ago, involving the football coach from Washington State who knelt and said a prayer at the 50-yard line after games, and the question was whether that was permissible or not, whether that was a violation of the Establishment Clause or a violation of his free exercise rights under the First Amendment by denying him that opportunity. And the court in that case indicated that because that dealt with high school students who were able to draw distinctions between coercion and just being exposed to something, that was a factor they took into account in allowing the practice there. Here, the court found that because these are young, impressionable students, that we should really be deferring to their parents' wishes and allow them to control the upbringing of their child religiously.
So in this case, there's something called the Establishment Clause, which I think you probably should, you kind of touched on it before.
Yeah, let's provide that just by way of background for folks who might not be familiar with it. When we created the Constitution, after our country was formed, the Constitution itself really has nothing to do with the protection of people's individual liberties. It's a blueprint for this new federal government that was being formed. It had checks and balances, order of succession to the presidency, et cetera, et cetera. But the Founding Fathers knew that we just fought a war to break away from a distant government that was unaccountable to us, and they were very concerned, in order to sell the Constitution, that people in the colonies be reassured that their personal rights were not going to be infringed by doing the same things that Britain did to us when before we fought that war and won it. So they tacked on to the Constitution this list of amendments that we call for short the Bill of Rights. And the First Amendment, ratified in 1791, covers a number of abuses that the colonists had experienced, and it covers a number of protections, including two religion clauses. One is what we call the Establishment Clause, which says there can be no state-sponsored or state-established religion. And then they have, right in the same sentence, the Free Exercise Clause, which says that people shall be entitled to the free exercise of their religion. So you have one clause that guarantees you, so to speak, freedom from religion, and another that guarantees you freedom of religion. And for years, certainly going back to the 70s, there's been a tug of war between different factions of the court over which takes precedence over the other. And for the longest time, up until fairly recently, the court placed most emphasis on the Establishment Clause and how things would appear to people. More recently, over the last 20, 30 years, as the conservative majority has taken hold on the court, they have placed more primacy on the Free Exercise Clause, where there's a tension between the two, and said that takes precedence. And certainly that was a driving factor behind the court's decision here.
So I was taken by reading some of it. They looked at this curriculum that it was not teaching, it was kind of a indoctrination of a kind of a philosophy.
Yes, yeah. They used the word normative. They said, look, this is not like you're teaching a comparative religion course where you're simply exposing people to different religions without trying to indoctrinate people into which religion they should believe in or whether they should believe in a religion at all. They used the word normative to describe these materials, and they actually included, very interesting, both the majority of court and the dissenting justices included the actual materials that were being taught in the classroom. So anybody who wants to read the decision will see right in there, so they don't have to take the justice's word for it, what these materials actually said. And I think it's fair to say from reading them that they simply did not expose children to the fact that LGBTQ people exist, that they made contributions to society, that they deserve to be respected. It went further than that in the majority's view to say that LGBTQ, that sexuality is something to be celebrated. It's a good thing. And if you don't agree with that, there's something wrong with your thinking, according to the majority. And by crossing that line, trying to take these young impressionable children and teach them that there's a right way of thinking and a wrong way of thinking about it, when that conflicted with the parents' own views on that matter, that is where the court found that this material crossed the line. It didn't just focus on the materials themselves. They looked at some discussion guides that the teachers were given, which told teachers how they should answer questions. If children asked them, for example, there was something in the discussion guides that said if a child asks you what transgender means, they encourage teachers to say, well, when you're born, people make a guess about what your gender is based on your body parts, but sometimes they guess wrong. What gender do you identify with, or words to that effect? So very clearly attempting to, if you believe the school district, their own version of what they were trying to do was to change people's thinking. And that is where the court said that crosses a line. It's one thing to teach religion and expose kids to religion. It's another thing to have Sunday school, so to speak.
So as we look at that, you mentioned the minority. I mean, I don't want to get into it because too much, but what was the minority's view on this? We have to deal with the majority's decision, but what was the minority view on those same facts?
Well, they sounded the alarm bells. They said, look, if you're going to allow children to opt out of sitting in classes with these materials, where does it end? Mm-hmm. Are you going to allow children to opt out of science classes because their parents may disagree with evolution? Are you going to allow them to opt out of math because somebody might take the position that math is evil? At what point where does this end? And how can we reconcile this with the fact that states have mandatory curriculum that in order to graduate with a high school diploma, you have to establish mastery in certain areas? Even if we allow folks to opt out of this, what does it mean in terms of kids' eligibility to graduate from high school? Does it mean we automatically give them credit for courses they didn't take? So the minority's position was there's no limit to this. It's going to be impossible to manage, and we're not going to put the genie back in the bottle now.
So how will this kind of affect us and the school district as we start to move forward on this? What should districts look? Because I could see both sides on this one. You can see how do they distinguish what's a religious belief? Like evolution is a good example of that. Would it be possible that would be a future case?
Well, we really don't know. And what I mean by that is when the Supreme Court decides a case, they obviously have to decide the particular case before them. And to that extent, they have to focus on the interests of the particular parties in the case. But usually when the Supreme Court gets to a case, and because it gets to the Supreme Court level, they're looking at the next 100 or 1,000 cases that are going to come after, and they paint with a very broad brush and try not to get too specific when they come up with these new rules. So they've given us some general guidance that we really don't know how it's going to be applied by the lower courts. So we're not too sure as to how the lower courts are going to answer a number of questions. For example, how broad is this opt-out right? Can you object not only to discretionary material that a school district wants to include, as this LBGT theme material was, or will people be allowed to opt out of mandatory courses that are necessary for graduation? We don't know that yet. We're dealing with young elementary school kids here who some would say really aren't in a position to make up their own minds on these things. How will this apply to middle school and high school kids who may have disagreements with their parents over what material they should be exposed to or not? Who gets the say there? Does a 10th grader's decision take precedence over their parents' objection to it? We don't really know how broad the courts are going to interpret that. Before the ink was even dry on the court's opinion, a number of advocacy groups around the country were taking the position that this applied to far more than just coursework, that if parents objected to anything going on during the school day at school that conflicted with their religious beliefs, they could opt their children out of that, including, for example, their children sharing restrooms and locker rooms with LGBTQ students if they objected to that. I don't read the decision that broadly, and the consensus among my colleagues is that we don't read it yet, but don't really know how some courts, perhaps in other parts of the country that are more conservative leaning, might interpret it. So a lot of open questions as to how it's going to be applied. It's been since June since the case was decided. Again, school was out then, so there wasn't any immediate impact because there was no coursework to object to quite yet until the school year got started in September. We're now, a little over 2 months into the school year. We're all kind of waiting for the other shoe to drop As I said, we represent about 100 school districts in one capacity or another, and we're not really hearing yet any drumbeat yet of parents, but we expect it will come. And there's tips that we've been giving our clients as to how to prepare for that, because you don't want to hire the fire department once the fire's underway. You want to be prepared to address these things. So a number of recommendations we've made to our clients I think make a lot of sense given with the decision. The first one is, you want to make sure that you don't have individual teachers and principals on the firing line making these individual decisions. We're talking about interpretations of people's constitutional rights, and it's unfair to put teachers or even building principals in the position of making these very nuanced decisions. So we recommended, for starters, that districts identify somebody in the district, usually at the central office level, somebody who has the board attorney on speed dial, if you will, to address these issues when they come up, because for all we know, there might have been further court decisions decided between Mahmoud and the time we get that call that may shed some light on what's going on here. I think it's a good idea to have conversations with your professional associations to make sure that everybody's on the same page as to who's going to be making these decisions. To the point you raised about how do we tell whether something is a religious objection or not, the court made clear, and there's a whole line of cases that address this, that we're talking about not just any religious objections, but sincere religious objections. How do we tell if something's a sincere religious objection?
That was going to be my follow-up question.
Yeah, and we have some cases that speak to that. Look, we're not supposed to be judging people's religious beliefs, but there are some tests that the courts do allow us to use to determine whether it's sincere or not, which mainly focusing on whether people are speaking and acting and behaving as if it's sincere. If someone claims they have a religious objection to a particular practice, but by everything they're saying and doing at the same time, they're acting inconsistently with that, that would be an example of something that would draw their sincerity into question. But we have to be very careful that we don't cross that line into the area where we're actually judging people's religious beliefs and determining whether we think that they're valid or not. So there's some things we can do, some things we can't do. I think in the Mahmoud case, again, going back to the bad facts for the school district, the parents in that particular case were able to articulate pretty specifically what their religious beliefs were and how they conflicted with what was going on in school. So I think we're at least allowed to ask parents to do that much.
So as we move forward on this, I could see if I was a teacher, this would put me in a tough bind sometimes on certain classes and certain curriculum. I may even have objections to it if I was a teacher, or they have to keep their own personal views out of this. And
They do. And again, teachers are entitled to their own beliefs on either side of these issues. And again, I make no assumptions about where a rank and file teacher may stand on these issues. But, at the K-12 level, we hear the phrase academic freedom kicked around a lot, but there are court cases that tell us who has academic freedom and who doesn't. At the college level, for example, there are court decisions from our federal courts that make clear that because of the role that colleges and universities play in our society, professors there have a lot more academic freedom to be saying things. They're not just there to teach a specific curriculum that has been handed to them by the school district. At the K-12 level, however, it's generally understood that teachers are there to teach a curriculum that the school district has decided is the curriculum they want to be taught. Even the school board's hands are tied to some extent because we have certain basic learning standards that the school district is required to implement. So we don't expect teachers, obviously, to be robots. We invite some creativity, but they can't use their classrooms as a soapbox, if you will, for their own personal views. They have to work within the four corners of a curriculum that they've been given. So even if they have their own views about this, there's a point beyond which they cannot really express those. They have to keep them to themselves. As private citizens, at a board meeting or in a letter to the editor or what have you, they're free to express their opinions up to a point, but not to a captive audience of young, impressionable kids in their classroom.
Going back to what you talked about, the sincerity, I guess that we have to encourage good communication between the school district and the parents.
We do, and again, a lot of school districts in the wake of this decision are wondering, well, what do we do? Do we just kind of keep a low profile and wait to see if anybody objects and hope that nobody does? Do we want to be proactive and advertise more proactively what our curriculum really is so that we know in advance if we're going to get objections and can be prepared for them? My advice to school districts is, and school districts should be doing this anyway, but one of the roles of a school board is to be in touch with your community. And the members of the school board and certainly high-ranking administration should know whether there are clearly identifiable religious communities in their district. And I've always encouraged my school districts to establish lines of communication with community leaders generally. That would include members of the clergy. And that can come in very handy where a parent is raising a religious objection. If you have a local clergy person who is from a particular faith that you've already opened up a dialogue with for other reasons, to do a quick fact check to see whether or not the religious obligation that somebody's presenting to you really has any basis. That can be tricky itself, depending on the religion. I know, in my own tradition, we joke around that if you ask, 3 rabbis a question about Judaism, you're going to get 4 answers. But in other religions, perhaps, the doctrine's a little more, there's more of a consensus and there's more of a clear answer about whether something's an obligation or not. So, I encourage districts to do that as well.
I would think, I know you alluded to this before, we've had opt-out in New Jersey for, do you need to have a clear policy on the opt-out? And I also think in this case, they didn't have another, they didn't have an opt-out, but if someone opts out in New Jersey, they usually have another curriculum or something else that they're doing.
Well, some do, some don't. Districts, we've been dealing with opt-outs of our sex ed curriculum for years, and every district has some way of dealing with children who opt out of that. They have some other material that they're being exposed to during that period. But our legislature has specifically allowed for that opt-out. For other things where the legislature hasn't specifically granted an opt-out, but somebody's raised a First Amendment religious objection, we don't really know from this opinion what we're supposed to be doing with those children when they opt out. Where are they going? Are we required to be educating them during that period with something else? Do they lose credit for not having been in that class if it's a course that is required by the state? We don't really know the answers to that, so districts are going to have to take calculated risks, if they will, when they take positions. And part of our job as school board lawyers is to make educated guesses about how the court in the next case is going to decide it, and then try to back into that result by advising our clients accordingly.
So a district probably should be proactive. You can probably guess pretty good where, or accurately, where you might get some objections, and think it through before any objections come.
Well, certainly, if you know that you have a readily identifiable religious community or multiple communities who you can anticipate based on the curriculum you're teaching, you have reason to believe in advance are going to object. You've got a number of options as to how to deal with that. If you're anticipating you're going to get objections, you can do what the Montgomery County School District did not do in this case, which is arrange the school day in a way that can make opt-outs more logistically feasible. The problem that the Montgomery County School Board had in this case is that they required the teachers to use these materials throughout the school day. It wasn't shoehorned in a particular course or a particular period where if somebody wanted to opt out, it would be easy enough to do that. So districts that are anticipating religious objections to particular material, I would encourage them in advance to arrange the school day, if you will, in a way that will make opt-outs easier to deal with. And one of the administrative burdens the school district, raised here was, it's just not feasible to do. And when the court stopped laughing, they said, look, you were doing it until for no particular reason you changed your mind, because from the court's view, they were getting pressure to change their mind, but nothing that made it logistically, impossible to do. And then they said, well, our other objection is that if we allow too many people to opt out, it's going to make the kids left in the classroom feel stigmatized and singled out by all of their friends leaving. And what the court said there was, look, this is a problem of your own creation. When you put this curriculum together, you knew that Montgomery County, Maryland was one of the most culturally and religiously diverse communities in the country. By arranging the curriculum the way you did, you invited this problem, which you could have easily solved in advance. Again, another example of bad facts for the school district in that case.
Is there anything else districts should consider as they move forward in areas?
Well, again, until we get guidance from the lower courts as to how this is to be applied in practice, we look around for other models of how we deal with accommodation requests in general. Now, under our discrimination laws, when people think of our discrimination laws, most of our discrimination laws prohibit government and employers and other people from treating people worse because of their membership in some legally protected class. It doesn't typically require to treat people better or to give preferential treatment. There are two protected categories where we're actually required to give preferential treatment under our anti-discrimination laws. Disability is one, religion is the other, where we have an affirmative duty to accommodate religious beliefs where people may actually get treatment that's better or different than other people. This is one of them. Where you are required to do that, I would say that you should be prepared to do it in a way that doesn't give carte blanche to people, because even under our current court majorities rulings, you don't get an accommodation just because you ask for it. The operative term is a reasonable accommodation. And the court left open the possibility here that there could be, and maybe even in Montgomery County case, there might have been a situation where the burden of accommodating that request was so unfeasible, that it really was unreasonable. The school district wasn't able to make the case here, so they left open the possibility that there could be a burden that's so great that a district can say no. One thing I do encourage districts to do is, until we get guidance otherwise, to use the way that we deal with disability accommodation requests. When someone makes a request for a disability accommodation, let's say a teacher comes in, says that there's an air quality issue in her classroom and she wants an air conditioner, a very expensive air conditioner, the disability accommodation laws say we're supposed to have what the courts call an interactive discussion with that person. What do you really need? What's the real problem here? What can we really do to accommodate you that doesn't put us out unduly? And to have that back and forth discussion. Matter of fact, if you don't have that discussion, you're automatically dead in the water under disability. So I encourage districts to have that same type of interactive discussion with parents who are making religious accommodation requests. You may find out through that discussion that perhaps there is a way to accommodate it in a way that neither side had thought about it ahead of time. And districts shouldn't just reflexively say no because they're suspicious of the sincerity of it. They should go through that process. And I think by going through that process and by arranging their school day in a way that opt-outs can be done without turning the school district on its head, I think that's a way that districts will be able to deal with this.
And I think probably as we move forward, my guess is, and not, you're the attorney, but there might be more cases. You already said earlier on that some of the advocacy groups are looking at this and taking it, they interpret it a little bit differently. They have a wider view, not a narrow view of this. They should be aware that there might be other cases that might be coming down the road. Maybe not New Jersey, but.
Well, that's true. And, that's the point I tried to make before, is that because, before the school year is over, I'm sure there'll be other decisions, either in our jurisdiction or around the country, that will have applied the Mahmoud case to particular fact patterns, some of the ones we're talking about here. And because you can't expect, folks on the front lines, the classroom teacher, or even the principal in the building to be aware of that, it's important that you have a direct line of communication to the central office and to the board attorney who can be up to the minute. I mean, these days, when I started practicing, if a case was decided, even by the Supreme Court, it would take a while for us to figure out what that was, just because of how news traveled so slowly back then. Today, if a case is decided at 10 a.m. in Hawaii, I can read it on my phone 5 minutes later. So there's no excuse for us board attorneys not being up to speed on what's going on around the country. You can't expect, school district staff to be. So it's important to, before you say no to a parent, to make sure that you have contact with the right people to make sure you're up to date on what the latest rulings are.
Yeah, and so just for our audience, David has an article in School Leader magazine. We have that link up there on this case. And probably if there's any a case after that, you could do a follow-up article, I guess. Well, thank you, Dave. David, for this. This was thought-provoking. I think it's something that the districts have to start looking at. I have one final. What should the board be asking their administration when we forward our curriculums? Should they have this in the back of their mind, some of the legal ramifications of?
Sure, absolutely. I think when districts are developing their curriculum, they should have their finger on the pulse of the community, know what religious communities exist in their communities. Perhaps, again, in contact with local clergy, try to anticipate whether there might be religious objections to some of the material there and plan ahead for it. We've discussed, just in this conversation we've had, some tools the school district has and some strategies that they can get ahead of the game, but not to put your head in the sand and just wait for something to happen and, have to be chasing after the train once you're already in federal court.
Yeah. Okay. You don't want to be the deciding case.
Well, it's the point here is that, like with a lot of things in our field, you want to choose your battles. Nobody wants to be the next test case. So even if it's a case that you might win, and even if you feel strongly about it, being a test case and making a commitment to litigate an issue all the way up to the Supreme Court, you better have the resources put away to do that. And our job is not to help our clients win cases. Our job is to help them avoid them by planning ahead.
Well, thank you, David. I hope you all enjoyed this edition of Education Matters. I think it's a little thought-provoking, as Addie said in the chat room. I think it gives us a lot to think about as we move forward.